Now coming to the last topic under Article 19 Clause 1 Subclause A, that is Contempt of Court. Supreme Court of India has the power to deal with the contempt of the Supreme Court in the light of Articles 129 and 142 of the Constitution of India, read in conjunction with the Contempt of Court Act 1971. Article 129 clearly shows that this court, being a court of record, shall have all the powers of such a court of record, including the power to punish for contempt of itself. This is a constitutional power which cannot be taken away or in any manner abridged by any statute. Article 142 Clause 2 provides that, subject to the provisions of any law made in this behalf by Parliament, Supreme Court shall, as respects the whole of the territory of India, have all and every power to make any order for the purpose of securing the attendance of any person, the discovery or production of any documents, or the investigation or punishment of any contempt of itself. Article 142 also provides that this court can punish any person for contempt of itself, but this power is subject to the provisions of any law made by Parliament. A comparison of the provisions of Article 129 and 142 Clause 2 clearly shows that Article 129 cannot be restricted or abrogated by any statute, but Article 142 Clause 2 is subject to the law made by Parliament. The power under Article 142 Clause 2 is not the primary source of power of Court of Record, whereas Article 129 is a primary source of power of Court of Record. Hence, Article 129 do not contain any restriction as such as like Article 142 Clause 2. Now coming to the power of the High Court. The High Courts also enjoy similar powers like the Supreme Court under Article 215 of the Constitution. Article 215 provides that every High Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. The High Courts are also entrusted with the supervisory control over the subordinate courts under Article 235 of the Constitution. Article 235 provides supervisory power to the High Courts over subordinate courts. In this manner, under Article 235, a High Court is the guardian of the subordinate judiciary under its jurisdiction. Now coming to the definition of a court of record, the Constitution did not define the term court of record. It has to be understood from the definitions adopted by or the practices adopted in other jurisdictions. In Delhi Judicial Service Association, T. Sazari Court, Delhi versus State of Gujarat, the Supreme Court applied the term to a court whose acts and proceedings are enrolled for a perpetual memory and testimony. A court of record has two types of powers. First one is power to determine its own jurisdiction, and the second one is power to punish for its own contempt. A court of record has the power to determine the question of its own jurisdiction. Once a court has been declared to be a court of record by a statute, the power to punish for its own contempt automatically ensues. Such a court also has the power to punish for the contempt of the courts and tribunals subordinate to it. Supreme Court in the case Pallav Seth versus Custodian and others observed that there is no doubt that Supreme Court and High Courts are court of record and that the Constitution has given them the power to punish for contempt. This is an extraordinary power and is exercised only to uphold the majesty of judicial system. Such a power is very necessary to prevent interference with the course of justice, to maintain the authority of law as administered by the court, and thus to protect the public interest in the purity of the administration of justice. The law of contempt, with power of imposing punishment, ensures respect for the courts in the eyes of the public by guaranteeing sanction against conduct which might assail the honor of the courts. Indeed, the courts must be able to discharge their functions without fear and or favor. The contempt proceedings are intended to ensure compliance of the orders of the court and adherence to the rule of law. When there is a proceeding against a person for breach of court order, where he is bound by that order, the court proceeds against violator for enforcing its order for the benefit of person who got it. When there is a proceeding against a person who is not party to that court order, but he is conducting himself to obstruct the course of justice, the court will not allow its process to be set at naught and treated with contempt. The parties willfully disobeying order passed by Supreme Court and third persons knowingly rendering assistance to frustrate that court order are held guilty of contempt of court. In Om Prakash Jaswal versus D.K. Mittal case, the Supreme Court emphasized upon the need for the concept of contempt of court in the following words: availability of an independent judiciary and an atmosphere wherein judges may act independently and fearlessly is the source of existence of civilization in the society. The writ issued by the court must be obeyed. It is the binding efficacy attaching with the commands of the court and the respect for the orders of the court which deter the aggrieved person from taking the law into their own hands, because they are assured of an efficacious civilized methods of settlement of disputes being available to them, wherein they shall be heard and their legitimate grievances redeemed. Any act or omission which undermines the dignity of the court is therefore viewed with concern by the society, and the court treats it as an obligation to jealously guard against any onslaught on its dignity. The following acts are held to constitute contempt of court: insinuations derogatory to the dignity of the court, which are calculated to undermine the confidence of the people in the integrity of the judges; an attempt by one party to prejudice the court against the other party to the action; to stir up public feelings on the question pending for a decision before the court and to try to influence the judge in favor of himself; an attempt to affect the minds of the judges and deflect them from performing their duty by flattery or veiled threat; an act or publication which scandalizes the court, attributing dishonesty to a judge in the discharge of his functions; willful disobedience or non-compliance of the court order. Now coming to the topic contempt of court vis-à-vis Article 19 Clause 1 Subclause A and 19 Clause 2. Article 19 Clause 2, which acts as a restriction upon freedom of speech and expression guaranteed under Article 19 Clause 1 Subclause A, provides contempt of court as a constitutional restriction. The Constitution, which has given its citizens right to freedom of speech and expression, has given certain powers to the judiciary to guard against the misuse of the same. To prevent the right to freedom of speech and expression being so exercised that it damages the dignity of the courts or interferes with the administration of justice. Right to freedom of speech and expression does not embrace the freedom to commit contempt of court. And in the garb of exercising right to freedom of speech and expression under Article 19 Clause 1 Subclause A, if a citizen tries to assail the dignity of the court or undermines its authority, the court may invoke the power to punish for contempt under Articles 129 or 215 as the case may be. Any law made by the Parliament or the application of any existing law in relation to contempt of courts would tantamount to a reasonable restriction on the freedom of speech and expression. The defense of fair comment is available even during the pendency of the proceedings. In Ashwini Kumar Ghosh and another versus Arvind Bose, the Supreme Court held that while fair and reasonable criticism of a judicial act in the interest of public good would not amount to contempt, it would be gross contempt to impute that judges of the court acted on extraneous considerations in deciding a case. Now coming to the Contempt of Courts Act 1971. The statement of objects and reasons of the Act states that it was felt that the then existing law relating to contempt of courts was somewhat uncertain, undefined, and unsatisfactory, and as the jurisdiction to punish for contempt touches upon two important fundamental rights of the citizen, namely the right to personal liberty and the right to freedom of speech and expression, the subject required special scrutiny and consideration. With this statement of objects and reasons, Section 2 of the Act defined contempt of court. According to Section 2 of the Act, there are two types of contempt of courts, that is civil contempt and second one is Criminal contempt. Civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to a court. Criminal contempt means the publication, whether by words spoken or written, or by signs, or by visible representation, or otherwise, of any matter, or the doing of any other act whatsoever which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court, or prejudices or interferes or tends to interfere with the due course of any judicial proceeding, or interferes or tends to interfere with, or obstructs or tends to obstruct the administration of justice in any other manner. Now, coming to the important judgments, I refer to only those judgments which have nexus with Article 19, Clause 1, Subclause A. There are many other judgments which are related to contempt of court. I am not going to deal with all those cases. Now, coming to the first case, Sri C.K. Dafatri and others versus Sri O.P. Gupta and others. The facts of the case are as follows. The state of UP filed an appeal in Supreme Court against the judgment of the High Court, holding the dismissal of the respondent from service invalid. The appeal was heard by two judges of the Supreme Court, and the junior judge delivered the judgment on behalf of the bench, allowing the appeal. The respondent thereupon wrote, got printed and published and circulated a pamphlet containing scurrilous criticism of the senior judge using the word dishonest judgment, open dishonestly, deliberately and dishonestly and utter dishonestly. The respondent also stated in the pamphlet that the senior judge cleverly asked the junior judge to deliver the judgment, and that the junior judge told his line by writing what the senior judge told him to write. The President of the Bar Association of the Supreme Court and three other advocates filed a petition supported by the affidavits of the advocates about 4 months after the circulation of the pamphlet for committing the respondent and the printer and the publisher of the pamphlet for contempt of court. The respondent deliberately avoided service till the senior judge retired and then filed a counter affidavit containing an unconditional apology and fresh abuses of the senior judge. The court in this case held that under Article 129, Supreme Court has the power to punish for contempt of itself, and under Article 143 Clause 2, it can investigate any such contempt. The court further held that the Constitution of India makes Supreme Court the guardian of the fundamental rights, and hence it would not enforce any law which imposes unreasonable restrictions on the precious right of freedom of speech and expression. Under the existing law of contempt of court, any publication which is calculated to interfere with the due course of justice or proper administration of law by this court would amount to contempt of court. A scandalous attack on a judge in respect of a judgment or past conduct has in India the inevitable effect of undermining the confidence of the public in the judiciary, and if confidence in judiciary goes, administration of justice definitely suffers. Hence, the apex court in this case held that respondent is guilty of contempt of court. Further, court held that contempt of court also is required to pass the test of reasonability laid down under Article 19 Clause 2, that is, the law of contempt, if had to be applied as a reasonable restriction, as a restriction on freedom of speech and expression, then the same shall be reasonable and issued in the public interest. Now, coming to the In re Vinay Chandra Mishra case, the brief facts of the case are as follows. Messrs. Bansal Forgings Limited took loan from UP Financial Corporation and it made default in payment of installments of the same. Corporation proceeded against the company under Section 29 of the UP Financial Corporations Act. The trial court passed an order on the stating that the corporation will not seize the factory of the company. Further, the trial court directed the company to furnish security towards the loan. Against the said order of the trial court, an appeal has been filed in the High Court, and the arguments have been advanced stating that trial court has no jurisdiction to pass such order for payment of installment of loan, and further no security could have been ordered. In the High Court, when Justice Keshote, who was dealing with the case, put a question to the advocate of the company that under which provision the trial court has passed the order, the advocate started to shout and said that no question could have been put to him. The advocate also said he will get the judge be transferred or see that impeachment motion be brought against him in parliament. The advocate further said that he has turned up many judges. The advocate has created a good scene in the court. He asked the judge to follow the practice of the court. According to judge, in sum and substance, it is a matter where, except to abuse the judge of mother and sister, the advocate insulted him like anything. What he wanted to convey to the judge was that admission is as a course and no arguments are heard at this stage. According to the judge, it is not the question of insulting of a judge of this institution, but it is a matter of institution as a whole. In case dignity of judiciary is not being maintained, then where this institution will stand? According to the judge, in case a senior advocate, president of bar and chairman of Bar Council of India behaves in such a manner in the court, what will happen to other advocates? Accordingly, Justice Keshote wrote a letter to the Chief Justice of the High Court. The acting Chief Justice Sri V.K. Khanna forwarded the said letter to the then Chief Justice of India. By the learned Chief Justice of India constituted a bench to hear the matter. The bench, which has been constituted to hear the matter, took the view that there was a prima facie case of criminal contempt of court committed by Sri Vinay Chandra Mishra, the advocate of the company, and issued a notice against him to show cause why contempt proceedings be not initiated against him. Pursuant to the notice, Mr. Mishra filed his reply by affidavit and also an application seeking discharge of show cause notice, and in the alternative for an inquiry to be held into the incident referred to by Justice Keshote in his letter, which had given rise to the contempt proceedings. Mr. Mishra also argued that he is a senior advocate of the Allahabad High Court, and his connections with the various law organizations in different capacities to impress upon the court that he had a deep involvement in the purity, integrity, and solemnity of judicial process. Mr. Mishra also submitted in the affidavit that for his deep commitments to the norms of judicial process, as evidenced by his said status and connections, he would have adopted the usual expedient of submitting his unconditional regrets. But the facts and circumstances of this case were such which induced him to state the facts and seek the verdict of the court, whether he had committed the alleged contempt or whether it could be a judge committing the contempt of his own court. The court decided on the other grounds, but the important and relevant ground which is connected with Article 19 Clause 1 Subclause A and Article 19 Clause 2 is whether contempt of court is a restriction which can be imposed as a restriction can be imposed on Article 19 Clause 1 Subclause A, and whether it is covered under Article 19 Clause 2. If so, whether contempt of court has to pass the test of reasonability. According to Sri P.P. Rao, learned counsel appearing for the High Court Bar Association of Allahabad, contended that Article 19 Clause 1 Subclause A and Article 19 Clause 2 combined with Article 19 Clause 1G and Article 19 Clause 6 gives the power to the Supreme Court to suspend a member of the legal profession from practice or to remove him from the role of the State Bar Council under Article 129. The court did not appreciate this contention of Sri P.P. Rao, stating that the freedom of speech and expression cannot be used of committing contempt of court, nor can the legal profession be practiced by committing the contempt of court. The right to continue to practice is subject to the law of contempt. The law does not mean merely the statute law, but also the constitutional provisions. Hence, according to court, the right therefore is subject to the restrictions placed by the law of contempt as contained in the statute. In the present case, the Contempt of Courts Act 1971, as well as to the jurisdiction of this court and of the High Court, to take action under Articles 129 and 215 respectively. We therefore, the court held that therefore it do not see any conflict between the provisions of Article 129 and 215 and Articles 19 clause 1 subclause A and Article 19 clause 1 subclause G read with Article 19 clause 2 and Article 19 clause 6 respectively. That's how in this case the court held that the power of the High Court and Supreme Court under Articles 129 and 215 of the Constitution has to pass the test of reasonability laid down under Article 19 clause 2 and 19 clause 6, and specifically when when the order is restricting the right to practice profession of an advocate under Article 19 guaranteed under Article 19 clause 1 subclause G, then the restriction shall prove that it is issued in the interest of public. Now coming to the latest case, In re Vijay Kurle and others, Suyomotu contempt petition criminal number 2 of 2019, decided on April 27, 2020. The facts of the case are as follows. In the Suyomotu contempt proceedings initiated against advocates Vijay Kurle, Rashid Khan Pathan and Nilesh Ojha for scandalous allegations against Justice R.F. Nariman and Justice Vineet Saran, the bench of Deepak Gupta and Aniruddha Bose has held Vijay Kurle, Rashid Khan Pathan and Nilesh Ojha guilty of contempt and has listed the matter for hearing the issue of sentence through video conferencing due to the lockdown. The basis of the contempt proceedings was two letters dated 20th March 2019 and 19th March 2019 received by Chief Justice of India Ranjan Gogoi and other judges of the court, admittedly signed by Vijay Kurle, State President of Maharashtra and Goa of Indian Bar Association, and Rashid Khan Pathan, National Secretary of the Human Rights Security Council, respectively. The issues raised by the contemners are that the bench of Justice R.F. Nariman and Justice Vineet Saran could not have taken cognizance of the case because the case was not assigned to them by the Chief Justice, and that both the judges acted as judges in their own cause. That the bench has not suyomotu taken notice of the contempt and therefore the registry cannot treat it as suyomotu petition. That even in suyomotu contempt proceedings, the consent of the Attorney General is necessary. That the proper procedure of framing a charge is not followed because the defects at the initial stage cannot be cured by later orders or developments. That the judges were bound to disclose the source of information. Now, coming to the point, that is ruling on contempt, holding both the complaints as ex facie contemptuous, wherein highly scurrilous and scandalous allegations have been leveled against two judges of the Supreme Court. The Supreme Court said that though the alleged contemners claim that they are not expressing any solidarity with Matthews Nedupara, who is also facing the contempt proceedings, nor do they have anything personal against Justice R.F. Nariman, the entire reading of the complaint shows a totally different picture. The court in this case noticed that even if the contemners wanted to criticize the judgment on the grounds of misuse of power, they could have used temperate language. The court noticed that the contemner failed to prove the same, and in fact a perusal of the material shows that materials relied upon were a matter of public record. There is not an iota of evidence on record to show that Justice Katwala is close to Justice Nariman. The court in this case, while dealing with the issue, the right to criticize the judgment of the Supreme Court, held that no doubt any citizen can comment or criticize the judgment of this court. However, that citizen must have some standing or knowledge before challenging the ability, capability, knowledge, honesty, the integrity and impartiality of a judge of the highest court of the land. However, the court failed to understand how a person who has mere 7 years of experience at bar with unknown professional credentials, someone who has failed to check the spelling of the name of the judge he claims to have no knowledge of law, can adorn the robes of a judge to pass judgment on the judges of the highest court. Finally, the court held that truth as a defense is available to any person charged with contempt of court. However, on going through all the written arguments and the pleadings, other than saying that the judges has misinterpreted the judgments of this court or had ignored them, or that Justice R.F. Nariman was biased, there is no material placed on record to support this defense. The court held that the allegations are also scurrilous and scandalous, and such allegations cannot be permitted to be made against a judge of the highest court of the country. With this, the court in this case held that Vijay Kurle and others were found to be guilty of contempt of court, that is criminal contempt, and they have been punished under Article 142. With this, we finished Article 19 Clause 1 Subclause A and 19 Clause 2. I did not deal with Reliance Petrochemicals Limited case in this presentation, but I dealt it in the previous presentations. Please check that.